So, in our series on litigating high profile cases, I'm bringing you some interviews from local professionals, professionals across the country, about what it is to be involved with a significant case, whether civil or criminal. And today we're talking about the criminal side of it. And I have with me today Jeremy Mull, who is the prosecutor in Clark County, Indiana. Would you tell us a little bit about what you do, what you've done, how long you've been here?
Sure. My name is Jeremy Mull. I'm the prosecuting attorney in Clark County, Indiana. I've served here since approximately 2015 as the elected prosecutor, 15 or 16. Prior to that, I was the chief deputy prosecutor in Clark County for some years. Prior to that, I served overseas on behalf of the U.S. State Department International Narcotics and Law Enforcement Division. I served as the United States Police Prosecution Coordinator for Afghanistan, and then I was the chief legal advisor to the United Nations Police Peacekeeping Mission in Sudan. Prior to that, I was a deputy prosecutor in Clark County. I also have served 17 years as an adjunct professor of criminal justice at Indiana University.
So, in your experience over all these different occupations you've had, all these different places in the justice system you've worked, certainly you've worked with cases that were of a high profile nature or had a lot of media attention, right?
Yes, I have. Some more than others, but I certainly have been involved in cases where there was an extensive amount of media coverage.
How do you deal with that? What's your biggest concern when you have a case that the media contacts you on, they are wanting to be in the courtroom or they're at the courthouse steps, you have witnesses, you have victims to navigate? What's your biggest concern?
My biggest concern is complying with the Indiana Rules of Professional Conduct when it comes to interacting with the media. The Indiana Supreme Court has issued several guidelines for prosecutors that we must abide by when dealing with the media. And that can be a trap if you're not careful on exactly what you can say and when you can say it. So for example, when I'm announcing charges on someone, I'm always careful to make a statement that that person is presumed innocent until proven guilty, and that the charges are mere allegations that would have to be proved beyond a reasonable doubt. That's something that the Supreme Court wants a prosecutor to do. You are required to avoid saying anything that quote unquote could, I don't recall the exact standard, but inflame public prejudice against the defendant, in so many words, which is a very subjective standard. Even talking about the charges could do that in certain cases, depending on what the facts are. You must avoid talking about certain evidence that you have in the case. Any admissions that the defendant made are not allowed to be talked about. Certain forensic evidence that you hold cannot be mentioned by you. And there's other requirements. Obviously, polygraphs that were taken. You can't talk about criminal history of the defendant. You're supposed to avoid talking about that. And so there are many elements in a case that I'm aware of that are being relied upon me as a prosecutor in the prosecution of the case that I'm not allowed to discuss with the public or talk about publicly. I disagree with that rule. I think the public ought to know what the prosecutor's doing, why the prosecutor's doing it, and what evidence they're relying upon. But these rules do exist and have to be abided by. So abiding by those is number one, first and foremost, my primary concern when I talk to the media. Second, you want to make sure that the media is not going to do things to the extent that you can that are going to damage your case. Getting victims and getting witnesses on camera and saying things that are inadmissible in court that might be disseminated out there to the jury pool. Just trying to the extent you can, limit the information that gets put out about the case so that the jury pool is not tainted by information that's being put out. But I think as somebody who's worked overseas a lot and saw other legal systems, I'm a big believer that the public ought to be able to see what's going on in their court system, understand why the decisions are being made, and understand who's making those decisions so that there can be accountability in elections. And so I've always been a big believer that you, to the extent you can, inform the public through the media about what you're doing, why you're doing it. So that's another concern I have in a case, is making sure that I'm adequately communicating what decisions are being made and why I'm making those, so that the public can have trust in their justice system. And if they don't like how it's going, that they can elect other people to administer justice in a way that's suitable to them. But I think all those things are important in dealing with these cases.
You talked a second ago about media attention and having a media presence that can potentially put things into the news media that shouldn't be, or that are detrimental to the case, pieces of evidence that maybe you're arguing about in, say, a motion to suppress pre-trial, and then certainly their presence at trial can be an issue. What tools do you have as a litigator, as a prosecutor, to either limit the media's presence at a particular hearing, or limit the use of cameras? And certainly, as we've all seen with the Johnny Depp trial over the last several weeks, that was filed, as I understand it, in a jurisdiction that would specifically allow for the presence of cameras. That was a tactical decision on their part. I personally, as a former prosecutor, cannot remember a time when I would have wanted the cameras in the courtroom, but I wanted to see if I could get your take on that.
Yeah. Well, Indiana's had a long-standing rule that cameras are not allowed in courtrooms. Those proceedings are not allowed to be televised, recorded, broadcast in any shape, form, or fashion. I think that might be changing. There are some pilot projects that are being done around the state where the Supreme Court is allowing media to broadcast certain proceedings and trials in certain courtrooms around the state, and then they're going to assess that and what effects have happened as a result of that, and determine whether that is something that they want to do on a more widespread basis around the state. So those pilot projects, to my knowledge, are being conducted now, presently, in Indiana in a few limited courts. So, but notwithstanding those counties, typically what I see is that the news media will be in the hallway during these trials and hearings. They will try to get comments from people in the system before and after the hearing, but other than that, they will sit in the courtroom and take notes about what happened, but not be able to record any of that. So that's how things happen now. If you're wanting my opinion on recording in the courtroom, broadcasting, it goes back to the earlier statement I made. I think that proceedings need to be transparent, and people need to understand what's going on in their courts so that they can determine whether they like how justice is being administered. For far too long, what we've had happen is decisions are made in these courtrooms that the average citizen doesn't know anything about and doesn't know who's making them. And over again, as a prosecutor, I get rulings that are absurd out of the courtroom, absurdly ridiculous rulings on cases. I argue that certain individuals are dangerous, and based upon all the factors that anyone should be able to look at and recognize are going to hurt someone if they're let out of jail. And repeatedly, these people are let out of jail over my objection, and they go out and they hurt someone seriously, or they assault them, or they murder them, or they kill them. And the public often wonders, why is this person out of jail? How did this happen? Who made that decision, and what could the basis of that possibly be? And it's very difficult anymore for print media to do all those stories. As you know, newspapers are shrinking, they have less staff, and the information about who is making the decisions in the criminal justice system is just not getting out to the public. And the only way people have to get that information generally is to take off work and go sit in a courtroom all day and take notes and then try to disseminate that somehow, which is impractical. So the more that people can turn on their television or log onto their computer and watch, here's what the prosecutor's arguing, here's what the defense is arguing, and here's the decision the judge made, and here's the information that was based upon, then there can be a healthy, robust public debate on, do we like the way that our system's working? Do we like the sentencing that's being done? Do we like the way the bonds are being set? But what happens is people have to have confidence in the rule of law system. And when that confidence disintegrates and shatters and deteriorates, then the rule of law loses its efficacy in a country. And so that is the thing that separates civilization from chaos, and it has to be upheld, and I think transparency is the best way to do that. I can tell you that in other countries that I've worked in where the citizens did not trust their systems, whether that was in African countries where there were not sufficient judicial resources to address genocides, people weren't being punished, or whether that was in Afghanistan where there was so much corruption in the courts, people understood they couldn't get a fair shake, they will turn to alternative courts and tribunals, whether that's shadow courts, whether that's Gachaca trials in Africa, whether that's shuras and jurgas in Afghanistan, whatever it is, whether it's shadow courts that the Taliban run, people are going to find a forum where they feel like they can get some justice if they don't feel like that's happening in their courts. So the best thing we can do as U.S. citizens is have people watch our courts, see if they like what's going on, and then allow them to go out and make educated votes about who they want to be their judges and prosecutors based on what they're seeing. So I'm in full agreement with that transparent broadcasting.
What do you see as the role of the media, or how the media interacts with your victims and witnesses? Certainly you have cases where you have sex crimes, child abuse crimes, where most of the time the media, out of courtesy, will shield the identity of a victim. If you could talk a little bit about victim witness programs or the people in your office that you employ to help with those victims navigate the system in terms of a high-profile case.
We do have victims advocates that work for the prosecutor's office, and they will work closely with victims during a trial, before a trial, after a trial, to walk them through the process, to help them navigate the entire process. When it comes to talking to the media, that's generally up to the victims and the witnesses whether they want to do that or not. We can't advise them whether we find that to be advisable or not, but at the end of the day, that's just advice that we're giving. They have the right to talk if they want to talk. I have found the media to be, as you said, respectful and discreet about not wanting to reveal the identities of juveniles, not wanting to adversely affect the outcome of a case. I have found the local media to be good about that. But on the other hand, there's these countervailing pressures that they face of trying to get stories that are going to get lots of internet clicks, lots of social media sharing, and conflict always will give rise to those sorts of stories. Somebody that's unhappy with what's going on, the family member that's just outraged at the sentence that was gotten. Those are the sorts of things that they're always going to try to get those interviews. Find somebody who's upset about what happened. You can have a case where you can make 99 family members happy, and if one family member is unhappy, you can be assured that that will be a family member who will be on TV at 6 o'clock expressing outrage, the injustice, that sort of thing. So there's very few times when you just get the general storyline that, hey, an appropriate result happened here, it was a hard-fought battle and justice was done. Sometimes that story is ran, and certain reporters are more inclined to do it than others. But a lot of times what you can expect is just an effort by the media to try to find somebody who will express a contrarian position to the majority of the people who were involved, just to try to give the appearance of conflict and disagreement over all of it.
Do you have any illustrative cases that you've had that ended up being of a higher profile, or had anything interesting or different about them in terms of how the media covered them, how you looked at them as a litigator? We are talking in this course about modus operandi, and when you have the ability to try multiple offenses at once or bring in the defendant's previous conduct to show MO. So if you have any illustrative cases that would be of that nature, we would love to hear about that.
Well, not speaking directly to the MO question, but what I can say is that a case that I tried 2 or 3 years ago, State versus Joseph Oberhansley. This was a man who had murdered his girlfriend, had dismembered her, had cooked parts of her body, and then had consumed parts of her body. So I charged him with murder, life without parole, tried that case. He was convicted and ultimately sentenced to life without parole. In that case, there was a tremendous amount of media coverage due to the cannibalism allegations. And that's a case where we went to 2 different counties. I think we ended up having to engage in voir dire, or picking the jury 3 different times with 3 different jury pools before we finally came up with a jury that decided the case. And that was a case that even when we went hundreds of miles away in the state, we would come across a large number of people who knew about the case through the media. So that pretrial publicity can make it very difficult to select a jury in a case, and when the jury is selected, it's oftentimes going to result in that jury having to be selected in a county far away, transported here, sequestered, and kind of performing all their duties in isolation. Even with all that being said, it's difficult to ensure that the jury's not obtaining access to extraneous materials, the inadmissible evidence in a case that the media will often report. You know, for example, many times there's criminal history of the defendant that I can't talk about, but the news will report on that a lot. Prior murder convictions. This particular defendant had been sentenced to prison on a manslaughter conviction in Utah prior to this murder. That was widely reported in the media, but the jury obviously couldn't be told that under the Indiana Rules of Evidence. So, I was hoping that no member of the jury accessed that, and that came up in any way, because that could have resulted in a mistrial. So you're always concerned about all this information out there. The jury is admonished not to access it. But in these high-profile cases, story after story after story runs, and it's very difficult to ensure that the jury is not accessing any of that.
You can't unring a bell, as I tell most of my students.
No, you can't.
Yeah. The last question I have for you is that I remember as a prosecutor, every once in a while I'd get a case that would pop up, and I would have no idea that it was going to attract media attention. And twice it happened in my career with a misdemeanor that I did not see coming. And the media seemed to be interested in the case for reasons that were less than comprehensible to me. Have you ever had that happen?
It happens all the time. It's, I think one of the things that I find disheartening about much of the media coverage, as prosecutors, we're doing a lot of work to keep the community safe in a meaningful way. We're taking individuals who are dealing drugs, and if you leave that conduct unchecked, that's going to result in a trickle-down effect of a lot of burglaries. It's going to result in possible sexual assaults. It's going to result in driving while impaired, possible serious bodily injury, death cases while driving. Those drugs out in the community cause so much harm. And every time we're able to get those sorts of individuals incapacitated, incarcerated, you are saving untold numbers of citizens in the community from being victims of crimes. That happens routinely in the prosecutor's office, yet doesn't warrant any coverage. Yet I'll have a case where a custodian in an office building urinates on somebody's chair at nighttime over some grudge, and that's charged as a possible misdemeanor charge, and yet that'll get story after story after story done about that sort of a conduct. And so again, I think a lot of the mindset is, what kind of story can we run that we can put on an internet website, put on Facebook, that's going to cause people to want to click on it because it's outrageous, and then get ad revenue. And that runs a lot of our media cycle right now, unfortunately. There's a lot of stories to be done by the media on the setting of bonds. What bonds amounts are we setting? Are the assessment tools that the court's relying on accurate to determine who's dangerous, who's going to come to court? There's so much substantive work that could have a profound effect on how decisions are made and how safe people are in our community. Those stories are very rarely ever covered by the media, but instead it's the one-off stories about weird, odd fact patterns, like you said, many times misdemeanor level offenses that cover the agenda for the day for the media. And as a result of that, the public is not getting an accurate picture of what's going on and kind of what's happening in the criminal justice system.
That was my experience anyway, so I appreciate that.
Yeah.
Any last words you have for our students?
No. I would say that serving in the criminal justice system is a very rewarding career. It's more and more challenging every year. The forces in the world who are going to try to tear you down and destroy you if you're holding the line and standing for what right, just seem to grow stronger and stronger all of the time, you can expect to be under constant assault by some group or some force or some individual who is trying to destroy the work you're trying to do. And that just seems like that accelerates and increases as time goes on. But the fight is worth fighting. We need people who are going to step up and say, I'm willing to fight that fight and fight for the rule of law and order and justice and fairness in our system, and to engage in that. So I would encourage any of you watching this to say, that's me, that's what I'm going to do, that's the fight that I'm going to fight. Because I can tell you that having been in this for decades, that we need people who are willing to step up and continue to do this work. Thank you.
Great. Thank you so much, Mr. Mull. We really appreciate it.
Yeah.